Welcome to today's video. Today's topic, how to draft your own last will and testament. If you want a will and you want to stipulate in that document what should happen to your assets after you pass away, you must execute a will properly. If you do not do that, then your estate, your assets, your car, your money, your investments, whatever you pass away with would be distributed in terms of the law of intestate succession. That is in terms of what South African law says must happen to your estate. But if you want your will to be your estate to be distributed in terms of what you wish to happen after you pass away, you have to execute a valid will. And to execute a valid will is quite simple. Before you, you have an example of a template will. You start off by stating who you are, your name, surname, ID number, your address. You are an adult male or female, being of sound mind. Hereby declare this to be your last will and testament and state the following. Firstly, you cancel, revoke, and annul all previous wills, codicils, or other testamentary writings or bequests made or executed by you. Basically, what you are saying is if there is a will I executed previously, that might be somewhere in my home or with someone else with my attorney, I hereby cancel those wills. Those documents are no longer valid. This document, which you are signing now, this should be your last will and testament. Example, in your previous will, you stipulated that your car neighbor. Now your neighbor passed away, and now you want the car to go to your friend or to your son if you have a son. Under those circumstances, your current will be the valid, and we will look at that. Even if somebody pulls out the old will and says, look at here, a few years ago, he stated that the car should go to the neighbor. That no longer applies because we have a recent will or a will after that bequest, which states that the car should now go to a friend. Therefore, it is important to cancel your previous wills. You obviously want to stipulate more details about yourself. If you are married, to stipulate who your spouse is. If you have children, stipulate who your kids are. It's always nice for a child to see that mom or dad mentioned him or her in the will. Their name is in the will. You have to nominate an executor or executrix to your estate after your demise. Basically, this will be the person that will distribute the assets in terms of what you wished in your will. It can be anyone, it can be your best friend, your spouse, an attorney, your accountant, someone that you trust will do a good job after you pass away. And then you decide how you want your estate to be distributed. You can say, my car goes to this person, my money goes to that person, my policy goes to that person. You identify it in your will, as shown to you now on the screen. And you may call or you may request or direct that your executors not provide security to the master of the High Court. And lastly, you may say, you declare that I fully understand this document and that it contains my last will and testament desiring that it should have effect as such. Just before I get to the next or the last page, please remember that at the bottom of each page, you and your two witnesses must sign. That goes for the first page, the second page. On the third page, something different applies. There are spaces for you and your witnesses to sign. Therefore, on the signature page, only the signatures of your witnesses are placed in the spaces provided. You do not have to initial or sign at the bottom of that will. It's very important. But if you do decide to sign at the bottom of that will as well, and in the spaces provided for the signature, that wouldn't be a problem, but it might cause some confusion. It is very important that the witnesses who sign this will are in your presence. Therefore, the witnesses must see you signing this will on each page, and you need to see the witnesses signing the will on each page. They need to witness. You need to witness them, they need to witness you. That makes this logical sense to me. And secondly, these witnesses must be of sound mind and use witnesses who are adults, 18 years old. And most importantly, and it's very important, to use a witness that will not inherit in terms of your will. For example, these persons who you bequeath, or you say, John must get my car, Mary must get my policy, Tamlin must get my leather jacket, that person must get my motorbike. None of those specific persons must sign as witnesses because they are benefiting from the specific will. Therefore, in short, a will is very easy to draft. You provide details who you are, you simulate it's your last will and testament, you say who your executor should be, you stipulate what should happen to your estate, and you sign that specific document in front of two competent witnesses, and each page of that will should have a signature on it. That is a long and a short of drafting a will for yourself, and we wish you all the best in that specific regard.